Good afternoon. Welcome to the joint Veterans Endorsement interview for judicial candidates. At the outset, we would like to formally recognize and thank the sponsoring organizations for making today's event possible. Veterans in Politics International, Nevada Veterans Association, and the Armed Forces Chamber. We also like to extend our sincere appreciation to the additional sponsors and community partners whose support helps ensure a professional, fair, and transparent endorsement process. Judge Jacob Reynolds, Clark County District Court, Department 29. Judge Mary Perry, Clark County District Court, Family Division, Department P. Judge Veronica Barisish, cut that up, Clark County District Court, Department 5. Danielle A. Tamaru, candidate for Clark County District Court Judge, Department 28. And Amanda Pellizzari, Las Vegas Municipal Court, Department 1. We're honored to have you here today. Before we interviews, let's go over the format. First of all, the panel members are going to introduce themselves. Then you, in turn, are going to introduce yourselves. Please include the office you're running for and explaining why you're seeking this position. Then we'll proceed with the interviews, and we have to state this is not a debate. At the interest of fairness and participation, we'll be strictly enforced. We'll ask a question. You will have a minute, 30 seconds to answer it. There will be no follow-up questions by the panel. The panel members will not be permitted to ask questions, so be ready for that. And at the end of the whole session, we'll give you another minute to reinforce and reiterate again for the public what position you're running for and why you're the best candidate for the job. So we'll start with Mr. Carnes at the end.
Bill Carnes. I am a panelist for the Nevada Veterans Association.
Cindy Lake. I'm panelist with Veterans in Politics.
Bradford Carlton. I'm here with the Armed Forces Chamber of Commerce.
TK Crabb, Veterans in Politics. And thank you guys for being here.
Thank you.
And again, JP Edwards, Armed Forces Chamber.
Trent Richards. I'm running for Henderson Justice Court, specifically Department 4. This is a new department, so there's no incumbent. And I'm here hoping you'll be happy with me and that I can secure your vote.
My name's John Cory, also running for Henderson Justice Court, Department 4. This is where we get background as well. So I'm a native to the Las Vegas Valley. I'm a fourth-generation Nevadan. Actually, I grew up in Henderson, though. Moved there in 8th grade and have been there pretty much the rest of my life. Did undergrad and law school here in town at UNLV, and am currently working at the City of Henderson as an assistant city attorney. I'm in their criminal division as a prosecutor. Been there about 4 years. Prior to that, was a prosecutor in the city of Las Vegas. Prior to that, did civil law, and prior to that, did bankruptcy, and prior to that, worked a lot with judges as a clerk and externing. So that's kind of my professional background.
Okay, thank you. As a note, when each panelist asks a question, like I said, again, you'll get a minute and 30 seconds. I will hold up the sign that says 30 seconds. After that, I will just let the alarm go and then on to the next question. All right, thank you. Bill, go ahead and start, please.
All right, we're going to jump right into it, gentlemen. What are your feelings on prosecutors stacking charges for a single offense against someone who's accused of a crime, yet they face multiple overlapping charges by prosecutors, effectively overcharging defendants?
I'll start with that one. I don't think it's necessary. I understand some of the reasons prosecutors do it. In the office I work at, we have made it a practice to look for what can be considered to be duplicative offenses, so that way we can start to clean up our complaints and try to move cases and these matters forward in a way where it is a little more manageable. And so, kind of long story short answer is I think ultimately the goal in my mind should be to seek justice, and that means what are the charges where we meet the elements of the crime? Do we have probable cause to charge these? And then if we can do so in a way that keeps the court efficiency, keep focused on that, so we don't have so many charges that it becomes burdensome for the court, for the prosecutor, for everybody involved. At a minimum, though, we have to be looking at justice. And so when we have the evidence there that shows probable cause, we have to consider whether to charge that. And if there's a reason not to, like it's just pretty much duplicative, then that may be a time not to do it.
I also don't agree with the everything in the kitchen sink mentality towards towards charging or a complaint for that matter in a civil arena. It's much more efficient if it's targeted, if it specifically identifies what they're seeking and they're going after, and it makes the entire process much smoother. That being said, it's the prosecutor's responsibility to charge what they feel is appropriate. It is the court's responsibility to give those charges a fair hearing, whatever that might be. So in the same vein, don't want to tell somebody else how to do their job, but I also I don't agree with throwing everything at it and hoping something sticks.
Okay, so in reading your bio, Mr. Cory, you said that you work tirelessly to keep the community safe. Is the community safe in Henderson? And as a judge, what would you do differently, if anything, than you do as a prosecutor?
There is the answer of yes, the community is safe as a general thought process, right? Henderson has excellent stats when you look at the numbers for the safety of Henderson citizens and the community as a whole. Of course, it has a ton of problems and a lot of crime. So to say that the city is safe would be very misleading. There's always the danger that crime is going to be happening, and that danger is very real. It does happen. Every day we get so many cases that come through. So in answer to that question, yes, the city is safe compared to many other places. It is safer than, but of course that work never ends. Crime's not going to go away, and we're going to have to keep working as tirelessly as we've already been working, and that's the only way. Go ahead.
I'll ask the same question for you.
I think Henderson is safe. It's a place I call home. It's a place I'm very happy to live. This new Department 4 that they are opening up, this is because the city of Henderson has reached, it is about 360,000 residents now. And so it warrants having a fourth department open to help deal with the caseloads, both in the criminal and civil side of things. They've actually warranted that new department for a little while. They've kind of held off on filling the position and opening it up. And so what you're seeing here and what we're both running for is really in furtherance of continuing to keep Henderson safe by making sure we can meet the needs.
Bradford Carlton, Armed Forces Chamber. So I want to take you guys back to law school for a second. In criminal law, we learned that the two purposes of criminal courts is rehabilitation and retribution. I'd like to know what your opinion is. Which one is it?
I don't think those things are always mutually exclusive. They sometimes can seem that way, but seeking justice, that's a nebulous thing. It's not always objective the way we might want it to be. You can travel to different jurisdictions and the same charge might carry a heavier sentence in this particular city or town versus this one because that the community there has decided that it's something they care more deeply about. So when we talk about retribution, I think the ultimate goal of our justice system is to keep the community safe, and that has to be paramount. However, one of the best ways to keep the community safe is to decrease recidivism, to help people get rehabilitated, to help people get out of a life that they've been living and get into a new place where they can actually become not just productive members of our society, which is obviously wonderful and important, but to get into a better place where they themselves have that rewarding life experience that they should have, that we want everybody to be able to have. So I think as long as we keep these two things in their proper place, retribution is a harsh word. It makes some people cringe, but ultimately that's what it's about. We have to keep our community safe. And in the process of that, anytime we can help someone get out of a bad life, that can be the goal and should be the goal.
Yeah, it's really both. They go hand in hand. It would be very awkward if we only had a situation in which we only did retribution. It'd be very awkward if we only had a situation in which we just did the rehabilitation. You really need both to have the highest rate of success. We do a lot of things to try and assist with that. For example, the Veterans Court is a huge success in the way it marries up veterans with benefits that they could be receiving from the VA and letting them take advantage of that to help reduce recidivism. It's part and parcel together.
Mr. Richards, thank you so much for your service.
You're welcome.
I appreciate that. And is your father Judge Cory?
That is correct, yes.
Okay. The reason why I ask, my uncle's a judge in Oklahoma, And then my former was the longest sitting district court judge here in Nevada, Don Mosley. So I'm sure you know who Don is. And having been around Don as long as we were in a relationship for 18 years. In those 18 years, you learn a lot of different things among the court system and the people. So anyway, my question is about power of the bench. A municipal judge has significant authority over people's lives, even in minor cases. What safeguards do you put in place personally to make sure that power is not abused?
You want me to go for it?
Sure, go for it.
So I have experience as serving as a judge pro tem down in the Henderson Justice Court. A judge pro tem is like the judge version of a substitute teacher because judges get sick, they have sick days, they have to go places, and so they'd call me in and cover the calendar for that day. So I have experience actually doing it, and I'd agree with that. And the thing that I do personally when I'm down there to make sure that we don't get into that territory is you have to take the time, especially in justice court, because a lot of the parties are not represented by an attorney. So they don't have somebody else that they're going to walk out in the hallway and get that information from. So as the judge, you have to take the time to explain to them in their own words, if possible, or the language they like to use, what's going on, why it's turning out the way it's turning out, why you're coming to the decision that you're coming to, and have that justification present for them. It makes the entire process much smoother, and it does a lot to, it helps me as well to kind of keep me in check as to why am I ruling the way I'm ruling? Well, I'm going to sit here and I'm going to explain the 1, 2, 3 steps about it, and that helps a lot.
We hear the term legislating from the bench a lot. I think that obviously becomes a problem in many circumstances. It's not always as obvious when it's happening, though. I've certainly witnessed as a prosecutor, we have standards that exist. The prosecutor has to prove beyond a reasonable doubt the elements of the charge. And, I've witnessed at times judges who will create their own template. We have this box of what it's supposed to look like, and they'll kind of create little new boxes inside. And if you don't meet this sort of stricter standard, then it's going to be a not guilty. And that's a form of what I think of as legislating from the bench. It's this idea of I have the power to do this, and I don't feel comfortable making this decision unless we are here at this little place I made up, and it's not what the law says. So in answer to your question, I think one of the best ways a judge can make sure that they're not getting lost in the delusion of power or the actual power that they do have is to just keep it simple. Follow the law. Apply the facts of the case to the law, and don't try to get out into new places. As a judge, you make uncomfortable decisions. You have to be okay with that. And if you're not comfortable with it, I think that's sometimes where we do get into those places. The last bit I'll add is just temperament. If you're on the bench because of an ego trip, then you're going to be at a higher risk to go into that place. But if you're there because you're trying to serve the community and follow the law, it makes things a lot easier to stay on track and keep things where they're supposed to be.
What are your thoughts on recidivism of individuals repeatedly prosecuted for statutory crimes with no victims and no monetary loss to anyone? Essentially, people prosecuted for financial free and victimless crimes of violating essentially black ink on white paper.
We see this at times with, I'll give you just one example, like traffic charges, for example. People who might they fail to go get their driver's license, and there may be good reasons at times. There may be life circumstances that make it tough for them. And, there can be a lot of compassion and understanding when someone has a rough time for a minute. Over time, though, 5th, 6th, 12th time that we see them in court, at some point we have to start making some serious decisions. When do we enforce this in a way that is likely to have a higher impact on them to try and get them to follow the law? And these laws do exist for a reason. They came about over time. This wasn't somebody sat down and just tried to get clever and try to imagine what dangers might exist someday. Most of these laws come about because of a problem that gets addressed through the legislature through statutes. And so, ultimately, it's kind of that same answer as before. We have a priority and the job of helping to keep the community safe by following and upholding the law. These laws are there, and so if somebody is violating the laws, even if it seems like there's no victim, when we have our community suffering the dangers of these different types of charges, we do have to address it. These laws need to be applied fairly to everyone, and that means enforcing them and following them, even if we don't have a person victim who's standing in the courtroom.
And I was going to use the same example, actually. You know, speeding on an empty highway when you're the only car out there is a pretty victimless crime. But we have the speed limits for a reason. It seems like a victimless crime, but the victim might actually be the person speeding when something goes bad. So the issue of the recidivism about it is, why is it happening? Why does it keep happening? And is there some problem, some deeper problem? I'm not above saying maybe the problem is the speed on that road is just too slow. That's fine. But maybe there's something going on with this individual that needs to be looked at. And maybe the solution needs to be a little more tailor fit to whatever's going on, whether that be the person or the situation.
Thank you. Okay, based on NRS Chapter 4, what is the civil and criminal jurisdiction of justice courts in Nevada, including monetary limits and exclusions like real property titles? How does this define the authority of the Justice of the Peace?
There we go. So Justice Court is a court of limited jurisdiction in Nevada. They basically handle 5 items primarily. They are landlord-tenant disputes. Second item is matters below $15,000. Third matter would be small claims. This is going to be your Judge Wapner, your Judge Judy, your people's court stuff. Fourth category is civil temporary protective orders. And the fifth category is really all crimes, at least at the preliminary stage, and misdemeanors depending on where it occurred going forward further on. That does have a big impact on what the court can and cannot do. And I'll give an example. The last 2 times ago when I was covering court, the matter in front of me was something of a dog napping case. And although what you would really maybe want in that situation as the judge is to give the dog back, the circumstance, the limited jurisdiction of the court does not allow that to happen. It was in a small claims setting, and you can only award a monetary judgment in that setting. So you couldn't do the thing you wanted. They couldn't even get the thing they were asking for. Now, the solution to that is to transfer that case, and there's a whole mechanism involved to transfer that case to a proper court that can give the relief that they are seeking, and they can go down that road and make that happen, and that's what we did. But it is a limited jurisdiction court, and it primarily handles those things. The current situation of how the court operates with the 3 judges is a judge. Of the 3 judges, they'll do a day where they cover evictions and landlord-tenant matters. The next day they cover small claims, and then the third day is a crime day, a criminal court day, and then they start over at the beginning again. So they're getting 2 days of civil stuff, 1 day of criminal stuff.
That was a very thorough answer. I really don't have much to add.
I do not know. We transferred that matter to where I hope so. They didn't bring the dog in. I wanted to ask the dog questions. It was not. It was a literal dog rustling case.
So you're running for Justice of the Peace at the Justice Court. Today, I've heard many judges say that they would all follow the law. They follow the law, follow the law. Everybody's been saying they'll follow the law. Would you ever make a ruling that does not follow the black letter of the law in the interest of justice?
I would not, and I'll explain why. There are mechanisms in place, appeals and different things that can be done, and I believe that is the appropriate way that if we believe there's an injustice with the law itself, because I believe that's kind of the scenario you're really describing, right? Like the facts of the case, when looking at the law, it becomes this sort of what we might call, it feels like an absurd result, or it feels like it's not, like the law is no longer serving the situation. But ultimately, the law is what we as judges are bound to follow. And so I believe we get into problems where we bring our own sense of morality, our own sense of whatever it might be that taints my sense of what justice is or supposed to look like, and we start ignoring the law in pursuit of something that I personally feel is the right outcome. Well, that's problematic. Ultimately, then we're relying on me as and my opinions and my background, whatever it might be religious beliefs, it might be anything influencing these things. The reason we have these laws is to make it fair for everyone, so it can be impartial, so it can be equally applied to all the citizens of, in this case, the city of Henderson. And thankfully, there are mechanisms in place for people to try to address what we believe may be deficiencies in the law.
Yeah, I'd agree with that assessment. Really, if what we're talking about is just a statute that we feel is not fair, not constitutional, for some reason like that, the proper arena for that to be addressed would be the district court as a general jurisdiction, and then to take an appeal from it if it needs to go that direction. It's not really squarely in the justice court's arena to be doing that. That being said, what I often try to do in a situation is to just get the two sides to agree, because then I'm not making a ruling that's counter to what the law is. But the law might be, this happens a lot in landlord-tenant actions. The law might have the tenant being evicted. Like that is going to be the outcome under the law. But if I can get the tenant and the landlord to come to an agreement amongst themselves and foster that happening of some sort of arrangement where perhaps they have some time, perhaps they leave the building in a good condition and peacefully, what are we going to do? Or maybe a payment plan. That's not what the statute has orders going, but it's a more productive resolution. But it only works when the parties want to cooperate.
If someone in your courtroom loudly accuses you of being unfair or biased, how would you respond in that moment?
There we go. The first is the courtroom. The courtroom is a team effort amongst the judge, the marshals, the clerks, the recorder if they're there, everyone cooperating together, doing their job. But it ultimately is the responsibility of the judge to make sure everything's running smoothly in order. So if we need to take a break, that's an option. Perhaps we need to take a sidebar where I need to have a discussion with them, because it ultimately lands on me as the judge. You need to get to the core of why are they accusing you of that and what's going on. And under some circumstance, maybe the answer is this matter needs to be transferred to another judge. That's fine. We have mechanisms for that. Maybe the answer is they're just not happy with the ruling. That's another situation. Maybe the answer is they just don't understand the ruling, and then I need to take the time to make sure I'm explaining it in a way in which they understand it.
I would say outbursts in court are very common. This isn't some abnormal thing. And so as a judge, I think it's important to remain calm. This is one reason why experience is so crucial for judges, is to have seen this. This isn't going to phase you. It's not going to throw you out of whack because someone's having a meltdown in court. And as Trent mentioned, there are mechanisms, there are marshals. I don't need to be jumping down and taking somebody on because they're, acting out. It simply comes down to this: is the judge's temperament matters a lot. The judge's temperament is what's going to help keep order in that courtroom. When the judge starts throwing their own tantrum because someone's hurling insults at them, then everything's going to devolve into chaos. So it's important to have judges who can stay calm, keep their cool, and not take it personally. There's ways to diffuse some of those matters when someone is upset. And I've during the course of my career seen judges do that very well. I've also seen judges struggle with that. And you follow those examples and you build those patterns of behavior within yourself where you don't take it personally and you don't get offended and start making ego-driven decisions. Instead, it's simply a matter of, if this is something that needs to be addressed, the person needs more time to explain themselves, we can do that. And you can diffuse that situation and show respect to everybody. And when things get to a certain breaking point, then we have to look at other alternatives. And when it becomes a safety issue, then we handle it differently.
You're not asking any questions down there, GP? All right. Again, Bill Carnes, Nevada Veterans Association. What qualifications under NRS Chapter 4 must a candidate meet to serve as a justice of the peace, such as education, examinations, attorney requirements in large townships, and any limitations on practicing law while sitting as a JP?
Sure. It has been a minute since I've read that, so I won't be able to give you a perfect list. You have to have a certain, you have to have, it depends on the township, right? And so once you reach a certain population limit, it has to be a licensed attorney. It also has to be someone who has practiced for a certain period of time. I believe for the Justice Court, it's 5 years. It's possible it's 10, but I believe for muni courts and justice courts it's 5 years. I may have gotten lost on some of that question, but essentially you're going to have someone who has a certain level of experience, time, licensed attorney. You cannot practice, have a side hustle going on as a judge, taking on clients and things like that for a township like, City of Henderson. As a judge, I would not be able to have clients and go represent them somewhere else.
Yeah, this is my opportunity to agree with him. Because Henderson, of its population, it has to be an attorney. They have to be licensed for a number of years. I'm not sure you have to live there. You might have to live there. Muni court, you have to live where you're a judge. And I would not be able to continue my law practice. It is a full-time job. So you have to separate from your law practice or whatever other job you're doing.
Cindy Lake, Veterans in Politics. What is your opinion on providing jurors with true and accurate information that fully informs them of their historical right to judge both facts and application of the law in a case, a fully informed jury approach, which may include the concept of jury nullification, as opposed to the standard judicially constrained jury instructions used in Nevada courts, where jurors are directed to apply the law solely as declared by the judge without questioning the law's validity or fairness.
So, in my experience, the jury instructions that the jury receives they are agreed to by the both sides, and then if there are any that are in dispute, then the judge would get involved. But for the most part, instructions that are given to jury, there is collaboration from both the sides they're presenting evidence as to what those jury instructions would be. So I'm not, and maybe other judges just come out and say, these are my instructions and this is what we're doing. That's not been my experience personally, and that's not how I would want to operate either. I think it's much more productive that the two sides have submitted the instructions that they don't have any dispute about, and then a separate pile of ones that we have some sort of disagreement about, and that's where the judge would come in and say, okay, why do you want this one to be worded this certain way, and why do you want it to be worded a different way? And you come to an arrangement and you work that out.
And I haven't seen personally information sufficient to me regarding those two different ones. The way we're currently doing it, I do believe is sufficient, and I haven't seen enough reasons to make me think that we should, or that it would be beneficial to change to a different type of jury information system. There are mechanisms in place. If we believe the attorneys, if I'm taking a case to trial and I believe a statute is unconstitutional, there are things I can do to challenge that. And so I believe the system works best when we have our judges following the law. I think the system works best when the jury instructions given to the juries keep them focused on what the law is and not on what we think maybe it could be if it was better somehow.
Bradford Carlton, Armed Forces Chamber. I'd like to know what improvements you would like to see made in the justice court system and what you would do to help implement those.
I'll start with this. I think from my experience in our justice court system, the one of the struggles that we have is what I will just term as inconsistency with the judges. When we have excellent judges who are making decisions based on the law and who have the integrity and temperament to apply the law to the cases, we tend to get not just reasonable outcomes, but expected outcomes. We tend to see people who challenge cases, and they will, at times, like in the criminal world, it's often said that the deck's kind of stacked against the defendants, and there's reasons for that. A lot of the cases that don't have sufficient evidence, these are going to get dumped early on. They won't even get filed on. So the only cases that are even being filed on are the ones that meet that probable cause standard, and there's actually a sufficiency of evidence for us to move forward on it. And when we get to the trial stage, prosecutors put on trials and lose them. Defense attorneys put on trials and lose them. We get mixed outcomes based on ideally the sufficiency of the evidence as it's applied to the law. And so, this is, I guess, turning into a long-winded answer. I'll try to wrap it up here. But ultimately, I guess that's the way I view it happening in the best way, frankly. Yeah.
For me, it's really the continued incorporation of technology into the courtroom and the court process. They've been doing a very good job. You might not be aware, but for them, largely a lot of the Henderson Justice Court, because it's Henderson Justice Court, there's still paper. It's still a paper file. You go in and they've got the judge has a paper file. I know they're already working on transitioning that to be digital, which is very similar, probably utilizing the same system that the district court in Clark County currently uses. Some of the other justice courts in the Valley have also made their own headway into having things digital. It makes the process a lot smoother. Obviously, the attorneys or witnesses' ability to appear via Zoom quickly is a huge benefit as compared to really before COVID when you didn't have that, or it was very archaic system. And so I would be interested in continuing that. I think that makes everything a lot easier. I'm a big proponent of it myself, and I prefer using it. I have no problem with dealing almost exclusively with digital documents and people on Zoom. So I would continue to push that and make it easier for the residents of Henderson to access the court records and their documents.
Tell us about a time you were wrong in a legal decision or professional judgment. How did you handle it?
Over the years, the many clients I've represented, there's been a number of times where the judge did not see things the way I thought or my client felt they should be seen. And so I was ruled against and I was wrong. There are avenues that my client and I can take when we feel that happens. Sometimes we've taken those avenues. Sometimes we decided that there's some other way to go about it, or we just accept what it is. It always feels bad. It never gets better. But if you can handle it with grace and understand why and move on from it and try to be better next time, that's the key.
You know, we are all human, so we will all make mistakes at times. And I think ultimately it comes down to having the integrity to go step up and say something. I don't know that I have a specific case in mind necessarily, as opposed to just a scenario, if that makes sense, where, in the course of communicating with defense counsel, for example, and extending an offer and having conversations, it's so important to be prepared to be able to actually understand what you're talking about. So you're not saying things incorrectly and misleading somebody. But in any given moment, things can happen where you, after the fact, realize, oh, I got confused on this and I thought it was one thing and it wasn't. Being able to reach out and have good, communication, having good connections and good bridges with opposing counsel and the people you're working with to be able to step up and say, excuse me, I made a mistake. We got to correct this. This was an error on my part and I was wrong about this and we need to set it right. It's been my experience that, most humans can be very forgiving of you when you make mistakes. The important thing is to immediately, quickly move to correct them anytime you get something wrong, because it comes down to your credibility and your integrity.
Bill Carnes, Nevada Veterans Association. So, under NRS Chapter 1, how does the Commission on Judicial Discipline operate, including grounds for discipline like misconduct or incapacity? And what forms of sanctions can it impose, and what procedural limitations protect judges during investigations?
I personally don't have any experience with coming before the Judicial Commission, so it's not something I feel super confident that I can give you an answer on, but it is something I'm willing to look into and get back with you about if you'd like some answer to those questions if you want to send them to me.
I do know at least some of these things. We've recently seen judges who've gotten into some trouble. There are ways that someone can be eventually removed from the bench. There are ways where someone can be suspended for a period of time, even without pay. Public, censure can be another form of discipline on it. There are times when someone may be removed from a certain type of docket due to issues they're having with that. For example, if it's a criminal versus civil thing, and if there's repeated issues going on with certain types of cases, then they may, have their docket shifted so that way they can avoid having these issues keep happening and put the person in an area where they're more comfortable or more experienced. So there certainly are numerous ways that we can address if a judge is doing something they should not be doing. And that same thing applies to attorneys. When attorneys are engaged in misconduct, there are ways to address that. The problem that often happens is just finding people who are willing to hold people accountable and willing to speak up about it when they see it happen, as opposed to just, kind of venting about it and then we all move on and nothing really happens.
Cindy Lake, Veterans in Politics. According to Article 6, we haven't asked this one, right? Of the Nevada Constitution, describe the vesting of judicial power in the state and the primary courts established. How does this framework limit the authority of judges to ensure separation of powers?
I promise I will try to answer this concisely. I think I followed along everything. So the Constitution ultimately is what creates the framework for us to have our courts. Now, the legislature obviously has to get involved in that process in delineating specific things about these courts. And so when we talk about jurisdiction, we have our Nevada Supreme Court, one of our constitutional courts, and then you start making your way down and you end up, even, for example, on the city level, not a state court, something that's, created by the city but allowed through the statutes that have been passed on all of this. So I'm not sure that there's something specific necessarily that you're maybe looking for in this answer, but that vesting comes down through a system that is not rocket science to follow, but it's not necessarily something where you can sit down for 3 minutes and suddenly have a clear answer. You'd have to put the work in to actually go through how the Constitution creates these courts and then how the legislature gets involved with that creation as you move down the line.
Yeah, it's definitely the very department, the very court we're both running for is a perfect example of exactly what you're getting at, which is, Justice Court has very specific, it's a court of limited jurisdiction. There are very specific things it can do, very specific things it cannot do. And there are limits, both dollar limits or just what they can order limits on different things. And so it's a perfect example of that. Different courts have different limitations: Muni Court, Justice Court, District Court, Appellate Court, Supreme Court, and they all operate that. Or even I also serve as an arbitrator. Up until December 31st, the limit for arbitration was $50,000, and now it's jumped to $100,000. So those things change over time as the legislature tries to meet the needs of our state. But it's something that we all keep apprised of, and that's the framework we operate within whenever we're handling a matter.
Bradford Carlson, Armed Forces Chamber. So with AI coming up, I can now make any image of myself doing anything. I can make any video of myself doing anything. I can create any audio recording with my voice saying anything I want. How does anybody prove anything in court in a legitimate way now?
Good question. That is a great question. And we'll always, it's difficult to answer because as technology moves on, we will find new solutions as well. So any answer I give now may not be the answer 10 years from now, right? But ultimately, so many of our cases have always been built on the idea of witness testimony. And that can be very confusing and frustrating for a lot of people at times. I think oftentimes we have an expectation that cases are proved through things like video, photographic evidence, things like that. But so many of the cases that come to court are based on a witness saying this happened. And convictions result based on the credibility of that witness throughout the course of that trial. And so in a weird way, when we get into this world of AI and the manufacturing of false images and different things like that, aside from the digital forensics that do exist that can be used to investigate the veracity of images and different things of that nature, there's also some legislation in place that does exist to try and control the existence of these images, their creation, and ways to try and safeguard us from so we can tell when they're created by AI. A lot of that's going to be a wild new frontier. That's going to, new technologies, new methods will emerge. But ultimately, one of the ways we will have is images coupled with witness testimony will be more powerful for a jury than just the image itself. The more this becomes prevalent.
It's really about can it corroborate the story? And that's kind of the same with most evidence. Obviously, it's going to increase the difficulty with certain things, but you'd be surprised how often in court it's simply a matter of asking the question, were you there? And they'll be like, no, I wasn't, or yes, I was. And so there's not really too much dispute. Or if they weren't there, can someone tell us where you were at? So if they're, I was the other person could say, yeah, they were definitely with me out of state or something. Well, that image isn't holding any water, so to speak. But we currently really do that. This is about, that's how evidence works. There are rules of evidence in place for that very purpose, and you have to go through each piece of evidence, and you need to authenticate it. Authentication means that it is what it purports to say. It's not a forged document, and then you have to have the evidence admitted, which is kind of another whole step in the process. But you're going to go through the same step with any AI material.
You're endorsed by political leaders and community groups. If one of those supporters appears before you in court, how do you ensure your decision cannot be perceived as favoritism?
Well, there is a difference between a genuine conflict and the perception of a conflict. And there are times when it would absolutely be appropriate to recuse yourself just based alone on the perception of a conflict. So it is incumbent upon the judge to be cognizant of that and to actually, to not just be cognizant, but to care, to genuinely try to safeguard the sanctity of our courts and make sure that we're not, putting ourselves in a position in that way. However, there are lots of times when many courts, especially in rural areas, they may not have the luxury of doing that. Ultimately, it's going to come down to your own ability to have integrity and to do that. As a prosecutor, I've had the situation before where someone comes before the court and I know them. Now, there's a difference between having met someone before or having spent time with them and having a genuine conflict. So it's important to disclose these things and make sure that all the parties are aware of it, so that way anybody who may have an objection can object, can voice their opinion, and we can resolve it in that way. And a lot of that comes down to the ability to, again, have integrity and to communicate clearly, so that way nothing's hidden, nothing's, later on people are finding out about some potential conflict that existed on something. Just avoid all of it. Just always be upfront and honest about it.
Yeah, I have two parts to this answer for me. The first is that the standard isn't that you can be impartial. It's that you can maintain that you appear impartial. So there are going to be situations in which I can be impartial, but if people don't feel I'm being impartial, then we need to handle it differently, even if I think I can handle it. We also, secondly, we have the luxury of there's nothing wrong with sending it to one of the other judges. That Henderson will, after this election cycle, will have 4 departments. There are other people that can hear this, so that you don't have that sort of a conflict. There's nothing wrong with that. And that's very easy to get it just transferred over, and everyone will be happier that way. The second part to your question is really the key. It comes down to explaining to their satisfaction that they understand why the decision is what the decision is. That alleviates a lot of problem. They're not going to feel like, well, this person's just deciding this way because they know them, or there's something going on, or they appear like, no, a very thorough record was made as to what happened, why, and the reasons behind it. And that usually will alleviate a lot of the problem.
One more round, or is that it?
We got time for a couple more questions.
Okay.
If anybody got any part 2 or 3 questions, you can do that first.
Here we go. As essentially all sworn statements, submissions, and evidence is seen as being submitted under the penalty of perjury. It needs to be authentic and truth to the best of the knowledge of the person submitting it or stating it. Considering many of those submissions in certain sorts of cases prove to be baseless or straight out false, AI could be one of those scenarios. Do you believe your position as a justice of the peace would provide you with the authority? And if you believe it would you consider actually holding someone who is repeatedly violating these covenants of the rules of evidence, holding them under the penalty of perjury in your court?
I don't have an issue with doing that to the extent that I'm able to do that. It is difficult, very difficult at times, to know what's really going on in someone's mind. So a lot of times these perjury style cases can be difficult to prove. There might be a high suspicion that someone intentionally was dishonest. It's a very different thing of, can we prove that in a way where there's a sufficiency of evidence to actually get there? But ultimately, as a judge, if you're unable to make uncomfortable decisions, it's not the right job for you, and you need to be able to do that, to be able to hold people accountable as it is appropriate to do so based on the evidence in front of you, and to not fall into, well, it's very suspicious, so we're going to go down that road. Suspicion is a very different thing from the standards that we work with under the law to hold people accountable. But when we meet those standards, then yes, you need to hold people accountable.
Two-part answer to this one too. For the first part, unreliable testimony, this happens frequently. One person says the light was green. The other person says the light was red. And it's up to the fact finder, it might not always be the judge, it's usually the jury, to decide who they're going to believe or to what extent they're going to believe one side or the other. So there is a little bit of a mechanism there. As far as a repeat offender, habitual offender, something like that, that gets into an interesting territory of whether the court would have jurisdiction over that person, what kind of jurisdiction they'd have over that person, and their ability to bring about some change directly. But I believe there's also some avenues available to the court if they felt somebody was being that way, that they could report it down the proper channels and have that looked into.
Okay, candidates, at this time, we're going to give you 1 minute each to again tell us why you're running for the position you're running for and how we can contact you.
Go for it.
My name's Trent Richards. I'm running for Henderson Justice Court, Department 4. I'm running for it because I enjoy doing the job, and I've been encouraged to go run for this department since I've been kind of covering as a pro tem. I can give you 3 perspectives on why I'm the best candidate for this job. No offense to my people running against. The first perspective is as to the specific court. I'm the only candidate that has experience doing the job I'm applying for, as I serve as a judge pro tem and have been for several years. Second perspective, as to the court as a whole, no matter how the election goes this year, what you're going to be faced with is 3 departments who the judge in those departments' background is criminal law. And so if you want a nice rounded court for Henderson, that 4th department, I am the candidate that has the civil background and will round out that bench. And then the third perspective is that as to just me individually, I have experience doing landlord-tenant law as an attorney. I have experience doing contracts as an attorney. I have experience doing all the things that come up and show up in front of the court as an attorney, and I believe I'm the best candidate for the job. I'd hope that you'd endorse Trent Richards and vote for Trent Richards.
My name is John Cory. I'm running for Department 4 as well in the Henderson Justice Court. As I've spent time in my career and in my life trying to, understand my strengths, my weaknesses, my experience, where I believe I can do the most good for my community, I do believe that being a judge is the place where I can do the most good. And given my experience, I have experience not just in criminal or not just civil, but in both. I've been a prosecutor for 9 years. In my early years, I've worked for multiple defense attorneys. I've handled both sides of the criminal matters. And just for clarity, not as an attorney on the criminal defense side, but working for attorneys. I've worked in civil. I've handled landlord-tenant issues, evictions, complex litigation, all these different matters. So when it comes to those qualifications, I do believe I am the most qualified. I have the experience, the integrity, and the temperament to not just do the job, but to do it extremely well. And I hope for your vote and for your endorsement.
Thank you, candidates. This will end this session of the Joint Veterans Endorsement Interview for the judicial candidates. Again, we'd like to thank Veterans in Politics International, the Nevada Veterans Association, the Armed Forces Chamber, as well as Judge Jacob Reynolds, District Court, Department 29, Mary Perry, Family Division, Department P, Veronica Barisic, Department 5, Daniela Tarmu, Department 28, and Amanda Pellizzari, Department 1. That'll conclude this session. Thank you.